Good afternoon, Your Honor.
Good afternoon. Who's ready? Mr. Graham?
Wanna go? He just has a reset.
Whichever one. Okay, I'm all right. Okay. Thank you. We're both too polite. Afternoon, Judge.
Good afternoon, Mr. Weiner. Is this Mr. Ryan Smith?
It is, Judge.
All right, court calls number CR 19-207, State versus Ryan Emanuel Smith for arraignment. Go ahead, Mr. Weiner.
Yes, Your Honor. We've received a copy of the charging instrument. I've been over with my client. His name is spelled correctly. He understands the nature of the allegations alleged against him within it, with waived formal reading and enter plea of not guilty.
All right, court will find that Mr. Smith has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. We'll set this matter for pre-trial. Mr. Weiner, are you available on Thursday, May 2nd?
We did June 13th. Thought so. Judge, I think the last time I was in court, you gave me the option of June 13th. Let me just pull up that. Is that a possibility?
Was that because you had a vacation letter or something?
I did. Yes, Your Honor.
The case specific.
I have a case, double check. I have a vacation letter for a good chunk of May. But I actually am open on May 2nd. If that's an available date, I can do that.
Yeah, let's go ahead. It's pre-trial, so we can set that for May 2nd, 9 a.m.
Great. And that's all I have, Judge. Might be excused.
Yeah, thank you, Mr. Weiner.
Yeah, have Easter.
You too.
Afternoon, Your Honor.
Good afternoon, sir.
Marola.
This is cause number CR 17-418, State versus Tina Marie Marola. Set for motion to revoke, motion to adjudicate. Are we doing a plea today?
Yes, Your Honor, we've entered a plea on this case. We have a plea agreement that we've reached with Chris Hartwell with the DA's office or the prosecutor's office.
All right. And what is your name, sir?
My name is John Paul Chidgey. I'm with the Richard McConaughey Law Firm.
Shitchy. All right, Ms. Marola, if you will, ma'am, raise your right hand on the place you wrote. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, ma'am. You can lower your hand. Ma'am, is your name Tina Marie Marola?
Yes, sir.
And Ms. Marola, you appeared before the court previously on March 12th, 2019. You pled guilty to the state jail felony offense of theft of property less than $2,500 with 2 or more previous convictions. The court heard the evidence that day and also the plea agreement that you had with the state, and the court followed the plea agreement. The court deferred a finding of guilt and placed you on community supervision for a period of 3 years and also assessed a $1,000 fine. It was during your period of community supervision that the state of Texas filed a motion to revoke and then an amended motion to revoke your community supervision. The amended was filed in February 2024. Ms. Marola, do you feel like you've had enough time to review this motion and the allegations in the motion with your attorneys?
Yes.
Feel like you understand everything that you've read and signed that's part of your plea agreement today?
Yes, sir.
I see that your proposed plea agreement is that you would be true to the counts contained in the motion, and the state's recommending to the court that you be adjudicated, your guilt be adjudicated, which means that you be formally and finally convicted for that theft of property less than $2,500 with 2 or more previous convictions, that your community supervision be revoked, and that the court assess your punishment under section 1244A, which is at the level of a class A misdemeanor, at 304 days in the county jail, with you receiving credit for all 304 days of time already served. In addition, you would have the fine and court costs and reimbursement fees imposed upon you that were previously ordered. Is that your understanding of the plea agreement, Ms. Marlowe?
Yes, sir.
All right. All right, Mr. Chidgey, do you believe that Ms. Marola is competent and if so, is she entering into this intentionally, knowingly, and voluntarily?
Yes, Your Honor, we do. I do believe she is competent, and I do also believe she's entered this voluntarily, knowingly and willingly.
Thank you. And is she waiving the formal reading of the state's move?
We are waiving a formal reading of the state's motion, and we are entering a plea of true.
All right, thank you. All right, Ms. Marola, I do have to tell you that the range of punishment for a state jail felony prosecuted under section 1244A is up to a maximum of 365 days and a fine which cannot exceed $4,000. Okay, I have to tell you about that. All right, so Ms. Marola, having reviewed the state's amended motion to adjudicate, at this time, I would ask you, how do you plead to counts 1 through count 8? Are those counts true or not true?
True.
And
True, Your Honor.
so the allegations alleged, you're telling me that those things that have been alleged against you are true because in fact they are true, correct?
Yes, sir.
All right, has anybody threatened, forced, or pressured you to plead true to any of these counts?
They have not. No, sir.
Court will accept the defendant's plea of true to each count as alleged. Mr. Chidgey, are there any objections to the admission of the defendant's waiver of rights and plea of truth?
There are no objections.
Defendant's waiver of rights and plea of truth is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Your Honor, at this time, we believe that there were some outstanding balances that were owed on this, and we're asking if the court allows her time served to cover those fees and costs.
Okay, the court denies that request. Does that change the plea bargain at all?
No, it does not. We were putting it on the court to ask. The prosecution knew we were asking, and if the court said no, they said no. We're not changing anything else. We just asked that take it into consideration.
Okay. And of course, the county will continue to work with Ms. Marola, set up a payment plan, and if she can't discharge that, then there's community service projects and things that we can do to make up the difference.
Yes,
Thank
sir.
you, Your Honor.
All right, then based on the evidence presented to the court today, the court finds that Tina Marie Marola has violated the terms and conditions of her community supervision. Based on that finding, the court will follow the plea agreement today. The court hereby adjudicates her guilt of theft of property less than $2,500 with 2 or more previous convictions. The court revokes her community supervision, assesses her punishment under section 1244A of the Texas Penal Code at 304 days confinement in the county jail. The court does award Ms. Marola 304 days credit for time already served. The court orders her to pay the balance of her financial obligations, which includes a $1,000 fine, $370.35 in court costs, and $407.65 in reimbursement fees. Ms. Marola, you're hereby remanded to the custody of the sheriff, so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted. And
Thank you, Your Honor.
Ms. Marola, whenever you do get released, then just report to the district clerk's office and inquire about setting up a payment plan.
Yes, sir.
They'll go over your finances and stuff like that, and we'll get you on a plan that's something. that
Thank you, Judge.
You're welcome.
Thank you, Your Honor. May I be excused?
Yes, thank you, Mr. Chidgey. Appreciate
Thank
you.
you. Thanks.
Ma'am.
And they'll say you're right. Give us back 2 seconds.
Mr. Manning, who are you ready on?
Judge, we can begin with Mr. Gladney.
All right, court calls cause number CR 23-214, State versus Trayvon and Lee Gladney, pretrial. Go ahead, Mr. Manning.
Yes, Judge, we were set for me to review videos that were provided at our plea setting last time. I was able to do so, but unfortunately I was unable to get them reviewed prior to the deadline set by the DA's office to get paperwork done. So we request that he be set out the next Thursday docket in order to plea. He's gonna be doing a plea for time, so he will be getting credit while he's still in here.
All right, the next available Thursday will be April 18th.
That'll work, Judge.
All right, court sets Mr. Gladney. Do you want to set that for plea?
Yes, please.
All right, court sets Mr. Gladney for plea on April 18th at 1. All right, who's next?
Next, ready on Mr. Mares, Anthony Mares.
CR 22-109, Anthony Reimer Maris, Damaris or Mars?
Mares, Your Honor.
Maris. Yes, sir. Maris. All right, this is motion to revoke. Go ahead.
Judge, we are not ready to proceed at this point in time. And I request additional setting on contested docket.
Objection from the state.
No objection.
All right, court sets Mr. Maris for a final hearing on the contested docket, April 30th at 1:30.
Next, we're ready, Judge, on Mr. Sprouse, Michael Sprouse.
All right, this is cause number CR 23-17, State versus Michael Raymond Sprouse for pretrial.
Yes, Judge, had an opportunity to speak to my client week before last. I believe we're close to reaching some sort of negotiated settlement, so I request we be set on docket call, and I'll continue negotiating with the state.
All right, you want that April 18th or something a little longer?
Judge, I think if we get the April 18th date, I should be able to have my negotiations finished at that point in time.
All right, court sets Mr. Sprouse for docket call April 18th. 1:30. Who's next?
Judge, next, ready on, well, I do not have the. I believe I left the indictment that I printed off for Mr. Roses on the printer. If we could pull up that to do his arraignment.
Rosas, you said?
Leonardo Rosas. CR 21-391. Judge, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment. At this time, we request to be set on the pretrial docket.
All right, court finds that Mr. Mr. Leonardo Daniel Rosas has waived the formal requirements of arraignment, enters his plea of not guilty into the record, sets this matter for pretrial hearing. You want that May 2nd?
Judge, this is my first meeting with Mr. Rosas, as he was recently transferred here. I believe this may be a mandatory probation case, so if we can set it for the 18th, I may be able to get something worked out with the state and get him on probation.
All right, court will set this for pretrial hearing on April 18th at 1:30. All right, who's next, Mr. Green?
Judge, next ready on Josue Rodriguez.
Rodriguez, if you'll come forward. All right, this is cause number CR 18-503, State versus Josue Rodriguez. Go ahead, Mr. Green.
Yes, Judge. I believe in the craziness of the past week and a half, I provided the state with a possible plea resolution on Mr. Rodriguez's case. Our options are a little more limited as to what we can do with his revocation, and so I've provided the state with some possible options. And we would request, as we're not ready for a contested today, we'd request to be set on the contested docket for 4:30.
Any objection from the state or any comment from the state?
No objection, Your Honor. We're continuing to look into the different options for Mr. Rodriguez.
All right, court will set Mr. Rodriguez for a final contested hearing on April 30th at 1:30.
Judge, next ready on Mr. Hanselka.
Selka. Clause number CR 21-169. It's my understanding that the state's wanting to withdraw their motion to revoke and continue him on community supervision. Is that correct with?
Yes, Judge, with the agreement that he is going to do safety as a condition of that probation, as well as have an amendment for his financials.
All right, Mr. Hanselka, if you'll raise your right hand, place your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Henselka, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you as your lawyer?
Yes, sir.
Like you've had enough time to talk with him about your case, and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
I already asked the question. She's gonna answer in a minute. Yes, sir. I understand.
Okay, is there anything that we're unclear on right now that we need to clear it up before we go forward?
I was just curious about the payment. If I'm to remain here, do I need to still have like my people, my family make the payment while I'm in the treatment?
And Ms. Burns, can you go ahead and answer that for Mr. Henselka?
Yes, your payments will stop until you are released. How much you are released, they'll be done.
Okay, yes, ma'am.
And so his payments will be suspended while he's in treatment?
That's correct, Judge.
Anything else, Mr. Henselka?
No, sir.
All right, Mr. Manning, do you believe that Mr. Henselka is entering into this agreement intentionally, knowingly, voluntarily?
I do, Judge.
All right, then the court finds that Mr. Henselka, the state's filed a motion to withdraw the motion to revoke and continue Mr. Henselka on community supervision with amended conditions of attending the substance abuse felony punishment facility, Safe Peak, and also incurring new attorney fees in the amount of $500. The court will amend the defendant's community supervision to include those additional two conditions based on the agreement, and the court will grant the order dismissing the or granting the state's motion to withdraw.
Thank you, Judge.
Thank you, Judge.
You're welcome, Mr. Ansel.
Yes.
You have a long.
You want next, Mr. Manning?
Judge, I apologize. I just got a communication from the state. If we may have just a couple minutes, I have some information to provide the remaining clients, as well as we're waiting on one correction on the judgments for Mr. Tadlock. So if we can just take a short recess, I should be able to get everything wrapped up and out of here in just a moment.
Yes, sir, no problem. All right.
Thank you, Judge.
Court will stand in recess.
City of- We're all trying to figure out.
Yes.
One ask about next to the last has to come by himself. And number one on the top has to come by himself. You just have two more inside these two.
Yeah, but those other two, are you gonna bring them both, or you said you just didn't bring one?
No, we are. Mr. Manning wants it.
I don't know to use.
We have P's and
November and then, Tadlock.
well, they're gonna go get your other two.
Oh, yeah. That's.
All right, so you ready on Mr. Tadlock?
Yes, Judge. And over the course of lunch, based on our conversation with Mr. Gould earlier today, I went and double checked something in 42A. And after discussion with the state, I think we're gonna have to redo our plea agreement. I've spoken to Mr. Hartwell about that. I spoke to my client about that. He's fine with setting this off. And so we'd request that earliest date, the April 18th date, for him to come back and do my understanding is that at this point in time, a deferred is gonna be offered in this situation. We just need to hammer out the terms with specificity and proceed forward. We'll get the paperwork ready.
Okay, so you are gonna abandon the shock probation recommendation?
Yes, Your Honor, our understanding is that shock probation would not be available in this case, so instead of trying that, we're gonna take a step back and make it work.
Okay, and I'll just go ahead and caution you as well, there cannot be an affirmative finding on a deadly weapon whenever we do. If there's a deferred recommendation, just make sure that the judgment, and I'm sure it says yes on this one because he was gonna be convicted of it, but if we do the deferred, then no affirmative finding on the deadly weapon, the court is prohibited from giving a deferred once there's
Yes, sir.
finding on deadly weapon. All right, so the court will reset Mr. Tadlock in all of his cases for April 18th. 1:30.
Well, Judge, since that'll be a probation plea, is it all right if he just comes at 9 a.m.?
Is he not in custody at this time?
No, Judge, he came to turn himself in for the shock probation.
Okay, yes, 9 a.m.
Thank you, Judge. Yep. So, yes, ma'am. Deputy, could you walk him out? Oh, sure. We don't normally do that. We'll talk about what's gonna take more. Do I need to wait around? No. Here you go. Yes. Didn't get much reset.
It's like this.
Judge, ready on Mr. Del Camry?
All right, this is cause of CR 24-00004, State versus Mark Lane, Del Camry, for pretrial. Go ahead, Mr.
Judge, at this time, we have no contested pretrial issues. Request to be set on docket call.
Want the April 18th or the May 2nd?
Judge, Judge, if we can do the May 2nd date.
All right, court says Mr. Del Camry for docket call on May 2nd at 1.
You heard about that, huh? That's of course. So, yeah. No.
Not yet.
Do you have something else?
The-
Okay. Okay.
So if you want.
All right, who'd you like next?
Judge, ready on Mr. Peace?
All right, this is written number WR 24-9. John Peace. Go ahead.
And Judge, I apologize. I can't hear you very well.
Said this, I've just called the case WR 24-9. writ seeking, bail reduction, I believe, for Mr. Peace.
That's correct, Judge.
I'm ready to proceed whenever you are, Mr.
Okay. Judge, at the time, I'd like to call my client. For limited purposes of bond.
All right, Mr. Peace, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, sir? All right, thanks, sir. You can lower your hand. All right, Mr. Peace, noted for the record, Mr. Peace is being called for limited purposes of the writ seeking bail reduction. Go ahead, Mr. Peace.
Mr. Peace, can you tell the court how long you've been in jail? Okay, if I said you were arrested on January 7th, 2024, would that be correct? Okay, and do you know what your bond is set at currently?
I do not.
If I said it was set at $20,000, does that sound correct?
I have no idea, sir.
Okay.
Yes.
Have you attempted to bond out in this situation?
In a situation?
In this current situation you find yourself in?
No, sir.
Okay. And do you have any financial resources or anything that you could use to bond out at this point? Okay. Where were you living prior to being arrested on this offense?
Yeah.
Okay. And did you own any property?
No, sir.
Did you own any vehicles?
No, sir.
Did you have any bank accounts?
Yeah, we don't.
Okay. Judge, are you able to?
Hey, Mr. Manning, I'm having a very difficult time, and Ms. Grisham is too. Maybe just have him move over there closer to it.
I'm definitely here, so I'm having a hard time hearing you.
Maybe y'all should switch sides then.
Yeah, here.
There we go. Let's try that, see if that works a bit. Go ahead.
Judge, I asked him if he had any financial resources, property, vehicles, and any bank accounts, and he responded affirmative that he did have a bank account, and he only had $3 in that bank account.
All right, thank you.
Do you have anybody that you can rely on to assist you in making a bond of $20,000?
No, sir. I'm with my girlfriend and my parents are both in a living facility because they're retired.
Okay. And prior to this, were you working somewhere?
No, sir.
Okay. And it is your testimony, you've been in jail since January 7th of this year, is that correct?
Yes, sir.
Okay. Your Honor, at this time, based on my client's testimony about his ability or lack of ability to make a bond, as set in this situation, his lack of financial resources, I asked the court to take judicial notice of his finding of indigence, as well as I would note for the court that at this point in time, while we are a couple days short of his 90 days, I do not believe that the state is going to be proceeding to grand jury prior to the expiration of his 90 days, which will be in a week.
Or we'll take judicial notice of Mr. Peace's indigency. Do you pass the witness?
I do, Judge.
State, any questions for Mr. Peace?
Still coming.
And Mr. Peace, where would you be living if you were to make bond?
Some are going back to the apartment with my girlfriend.
And
I talked to her on the phone once and she's.
Hold on.
I may have just a moment, Your Honor. And Mr. Peace, who is Carla Warren?
She is my girlfriend, yes.
Okay, what if there were to be a no contact order, sir? How are you gonna find a place to live if you are not able to make contact with her during the pendency of this case?
It would be a good question. Yes, I'm looking for a homeless shelter. We're trying to reach out to a family member who would be back in far west Texas somewhere.
And if you were to move out there, would you still be able to make your court appointments or dates?
It would be very difficult, but I guess I would have to, yes.
Well, it's not a matter of it being difficult. You realize you would be under court order and you have to appear.
All right, exactly.
And part of the reason why you'd be granted that, whether it be a PR bond or a reduced bond, was to guarantee that you appear in court going forward.
then I would find a way to make it. Yes, sir.
Would you have any concerns or problems abiding by any pretrial release conditions? One of those being obviously potentially your inability to have contact with Ms. Warren.
Asking if you would have any trouble abiding by the conditions. I'm sorry, Judge, Mr. Peace has difficulty hearing, and so I'm just gonna explain to him the question. Ask if you can abide by all the conditions such as to stay with of court report to pretrial release. Would you be able to do all those things? Those are conditions, those are conditions that would be added if you were released.
Yes, sir.
Was that a yes, you would have problems abiding by the conditions, or you don't believe you would?
If that's what the court says, and I'll abide by it, yes.
All right. I have nothing further, Your Honor. I'll leave it to the court.
Any follow-up, Mr.
Judge, I would note for the record, based on my interactions with Mr. Peace previously, that if this case goes forward, I'm gonna probably need to file a competency motion. So I just make the court aware of that indication. I'd also seek to provide Mr. Peace with some resources, possibly local, so that he can stay nearby and still make his court appearances if a case ends up getting filed.
Does the state anticipate indicting Mr. Pease before the expiration of 90 days?
And no, Your Honor, unfortunately not.
And Mr. Manning, I will note that I signed conditions of pretrial release in this case, and one of the conditions is that the defendant shall not communicate in any manner directly or indirectly with the alleged victim, or not go within 500 feet of her residence, school, work, things of that nature. So that condition is in effect at this time based on the nature of the charge.
Yes, Judge. And I don't know if those have been served on my client, but I'd also point to my statement regarding competency. I have spent quite a bit of time discussing this situation with Mr. Peace, but I'm not entirely sure that he understands the full weight of paperwork that I have not explained to him, and I have not been given that paperwork to explain to him. So if that paperwork is provided, I will take an opportunity to sit down with him before his release and explain explicitly what those conditions mean.
Okay, and those would be, so I'm gonna grant the writ, and I'm going to authorize a personal bond in the amount of $20,000, finding that Mr. Pease is entitled to it under Article 17-151. I am going to condition him on no contact with the alleged victim at this time. And so that information will be sent out with the order on the application with the writ. So Ms. Abraham usually sends that out after court. So
Yes, Judge.
he'll be required to sign that before he's released. So we'll just I'll tell you what, I'll have Ms. Barker email it to Ms. Burns. Can you print out there?
Yes, sir.
Okay, I'll just have Ms. Barker email it out to Ms. Burns. We'll
Thank you,
print,
Judge.
maybe we can get that done sooner rather than later.
Yes, Judge, and I will sit down with Mr. Peace before he leaves to go back to the cell and go over those with him.
Okay. All right, there's nothing further in this hearing, then we are adjourned to this hearing.
Thank you, Judge. Will you? I'll explain. Sorry.
All right, is this Mr. Daniels?
It is, Judge.
All right, this is written over WR 24-5. Robert Daniels, writ seeking bail reduction. Are you going to be calling Mr. Daniels for limited purposes of bail?
Yes, Judge.
Mr. Daniels, sir, if you will raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You put your hand down. During your testimony, just speak up loudly and clearly. Go ahead, Mr. Manning.
Mr. Daniels, can you please state your name for the record?
Robert Daniels.
And do you know the 3 charges you're currently incarcerated on here in Van Zandt County?
Yes, sir.
Can you state those for the record?
I think evading, resisting, and assault.
And do you know your bonds in total are currently set at 100,000? Is that correct?
I believe so, yes.
Okay. And do you have any idea when we were arrested on this case?
Believe January 15th, 16th.
And if I said that the bookend shows you arrested January 16th, would you feel like that's correct?
Yes.
Okay. Since your time in arrest, have you attempted to make bond in these cases?
No.
Okay. Do you have any financial resources that would allow you to make $100,000 bond at this point?
No.
Okay. Do you have a car?
No, sir.
Do you have any property?
No,
Do you have any bank accounts?
I do have a bank account.
Okay. And what's the at last check? Do you know what the balance for your bank account was?
I think I have a few $100s in there.
And have you communicated with your family and friends in an attempt to bond out of the situation?
I've asked a few friends, but none could help out with that much.
Okay. And isn't it true that you have a no bond hold for cases that are pending out of Travis County?
Yes.
Okay. And you understand that if the judge grants a bond reduction or a PR bond, that you will not be released from custody, but be transported down to
Yes.
Travis County.
Yes, sir.
And you also realize that if you're given a PR bond or bond reduction in this case and bond out, that you will no longer be getting credit for the time that is spent on these cases.
Yes.
You only have credit if there's a hold attached to you.
Yes, sir.
And is it your request that the court grants your PR bond even with those conditions in mind?
I will greatly appreciate it, please.
Your Honor, at this point, I pass the witness.
State your questions.
Yes, Your Honor. Mr. Daniels, the date of offense, were you going into the Wills Point Police Department for a standard compliance check that day?
Yes, sir.
At that point, did they inform you that you had a warrant?
Judge, I'd ask that at this point in time, we're getting into the particulars of the offense that are not relevant for purposes of bond.
And Your Honor, I don't want to go into any of the particulars of just leading up to basically none of the specific allegations, just went in for a check. These charges arose after that check initiated is what I'm trying to get at.
And Judge, I would just advise my client that while we are here for the limited purposes of bond, that things that he said can be used against him in future proceedings.
Okay, and so you want to know, so I believe he answered yes to your former question of whether he was going in for I guess it's a sex offender check, is that correct?
Yes, Your Honor.
All right, and I believe he answered yeah. What was your next question?
My next question was whether he was informed about a warrant at that check.
Judge, I
Warrant
think
out of Van Zandt County or
Out of Travis County.
Okay, I'll sustain the defendant's, how does that go to bail or bond?
Your Honor, I believe the evidence would show that Mr. Daniels, I'm sorry, is the court asking me to kind of proffer what the testimony that I'm trying to elicit? Or?
Yeah, well, just tell me what's the relevance to whether or not he was informed of a warrant? Are you talking about in a 17-151 or a bail factor that the court has to take under consideration in setting bail, or what's the?
No, Your Honor. Your Honor, it would go to his likelihood to abide by a court order. And the likelihood that he would return to court when ordered.
All right, I'm gonna allow you to argue it. I assume you have information. I'll allow you to argue that, but, I'm gonna sustain the defendant's objections to having the defendant answer that at this time.
Okay, thank you, Your Honor.
Any other questions for Mr. Daniels?
Yes, Your Honor. Mr. Daniels, if you are released from the Van Zandt County Jail and handle your business in Travis County, where will you be residing?
With my mom and Lois Blank.
Have you ever had any kind of difficulty making court appointments before?
No, absolutely, no, sir.
State passes the witness, Your Honor.
Mr. Manning?
Nope. No further questions.
And is it true that Mr. Daniels has not been indicted at this time?
Your Honor, he was indicted on the assault on a peace officer, but the other charges have not yet been filed.
And Judge, I apologize. I was unaware that he had been indicted on the assault of peace officer. Do we know when that occurred?
I think it was this past grand jury session. I'm not sure. I can give you the cause number. That'll give us some heads up. It's CR 24-00047.
Judge, in speaking to Ms. Taberham, she says that she hasn't got notice of that either.
What was the cause number again?
CR 24-47. And Your Honor, I do have a file marked copy of the indictment.
Yes, can I see that?
Yes, sir.
I don't show it to be maintained by the district clerk system this time. All right, Mr. Manning, I'm reviewing indictment cause number CR 24-47, State of Texas versus Robert Murrell Daniels II, assault public servant, third-degree felony. Did then and there intentionally, knowingly, or recklessly cause bodily injury to Aaron Long. Thereafter style complainants by knocking him down. The defendant knew that the complainant was a peace officer. The complainant was lawfully discharging official duty, namely attempting to arrest the defendant. So I don't show that this has been scanned in by the district clerk's office, but it does appear to be a proper indictment returned by the bench.
Judge, what was the date of the return on that?
It was March 15th, 2020.
Okay.
All right, anything further, Mr. Manning?
Judge, if I may have a moment to talk to my client.
Yes, sir, please.
Your Honor, I just spoke with Miss Elizabeth and she said they just got the list this morning. I think Mr. Crawford had been out or something and they've just now got that grand jury list. So they're working on getting the process to send to me.
Okay. Great, Mr. Mayor.
Yes, Judge. I think I see where the confusion came in. I filed my writ a month ago. And so it looks like the state indicted the case after the writ was filed. I'm not sure for the delay as to why it took so long to get set. But at this point in time, based on communication with my witness and based on the new evidence that's been presented, we would withdraw the writ at this point, and hold it in abatement until we can figure out what's going on with the newly indicted case.
Mr. Hartwell, was Mr. Daniels also indicted on the evading and the resisting?
No, Your Honor, well, let me make sure, I think those were going to be direct filed.
I didn't know if it was with a vehicle or. if it was something.
Yes, Your Honor. So it was a misdemeanor evading. That one does have a cause number, for the county court at law.
All right, can you give us that?
Yes, sir. 2024, 57.
2024-57 county court law evading arrest or detention. Okay.
However, the resisting arrest, it has not been filed. So Mr. Daniels, I believe qualifies for the 30-day bond on that.
What's the date information on the evading arrest or detention?
Your Honor, the file stamp is March 15th, so that was also past the 30-day.
Okay. Mr. Manning, you still stand on your argument of wanting to withdraw and abate until later time?
Yes, Judge, simply because if he's unable to make bond on as he's testified, he's unable to make bond on any of the cases currently. And so he would not be getting credit at this point in time. So we request that he continue getting credit on all charges. Additionally, Judge, I would note for the record that I filed my letter of representation with the DA's office and with the district clerk's office back in on February 20th of 2024. And additionally, Judge, at this point in time, I do in my letter of representation, as well as notifying both the clerk's office and the DA's office I was retained, I also requested notice under 3914 of all discovery materials. And at this point in time, I've not received those, nor do I show that I've been added on the portal to include any of the offense reports, videos, or supporting material for these cases.
Any response, Dave?
Your Honor, we're still working on getting everything into the portal. It'll be done as soon as we have it all gathered, and I expect that to be shortly.
Okay. It's noted for the record, Mr. Manning. Okay, all right, so the court will grant the oral motion to withdraw the writ at this time.
Thank you, Judge. Judge, I believe that concludes my business that is currently in here. I believe we have Mr. Boylan remaining. I don't know if the judge will give me an opportunity to explain Mr. Boylan just briefly before we get up what's going on and how we're proceeding.
Yes, go ahead.
Thank you, Judge. Okay. That's fine. You're on now?
Okay.
Just for a minute.
Judge, we'll be back in just a minute or two.
Any conditions on this?
And we still need the conditions on Mr. Pease.
I believe that Ms. Parker is emailing that. She kind of got it a minute ago, so it should be
Okay,
to
thank
this.
you, sir. Your Honor.
Yes, ma'am.
Excuse me.
Okay, we're ready with Mr. Boland.
Mr. Manning and Mr. Boyle. Yes, I believe so. Oh, it's good. Yes. I'm sorry. Yeah, no, Mr. Hartwell. Mr. Boylan, I didn't recognize you with your beard.
You look different.
Judge, I think he's lost a little weight too.
Yeah, you've lost some
Yeah.
weight, and I was like, who is this guy? Go get Mr. Boylan in here.
Right here in front of you.
What's that?
I said right here in front of you.
I know. I just didn't recognize you. That you got a little gray in your beard, like I got a little gray in my beard.
So Judge, I've explained to Mr. Boylan, why we are here. I explained to him that he expired, off of, the list at Montgomery County. I've explained to him, the waivers that we're making in this particular case, as it regards to the civil commitment. However, I also,
Do you want this on the record?
sure, Judge.
Okay, let me call the case. Stella doesn't go on the record unless I call the case, but I want to make sure you are gonna want a record and we not have one. Let me do this real quick. You said the word waiver, I was like, yeah, I better. You better get it. All right, court calls, for the record, calls number CR 22-88, CR 22-167, 168, 169, 170, State versus Gerald Robert Wood. Sorry to interrupt, Mr. Manning, go ahead.
Yes, Judge. I previously had the opportunity to speak to Mr. Boylan today. I explained to him, the reason he's back here is due to, his expiration at Montgomery County, after 6 months being there. I also explained to him that based off of the diagnosis that he has received previously, that he qualifies for a civil commitment, under the, Article, 46B 103. I've explained to him that we are giving up certain rights in regards to a hearing over his intellectual disability and civil commitment at this point in time, but we have not given up any of his due process rights and rights to contest the underlying case, criminal case, if he is ever rehabilitated to competency. I've explained to him the process that we're going forward today, that as long as there's no contest between us and the state, that you are gonna sign off, and then he will be put at the top of the list to go back to a hospital that has a bed available for him. I point out, he did remind me that there's several hospitals that he's been to previously that he requested he be sent to. But I told him that we have no control over which hospital has a bed and has the facility for treatment. And he understands that he will be kind of at the mercy of the system as to where he's placed to receive his continued treatment and rehabilitation.
All right, thank you, Mr. Manning. Anything from the state, Mr. Hartwell?
Yes, Your Honor. State would just ask the court to take judicial notice of the waiver of jury trial. Along with a few other things. I don't know if you want to kind of go piece by piece or everything all at once.
Well, I'll go ahead. I'll take notice of the defendant's waiver of jury trial on the issue of civil commitment.
Yes, Your Honor, specifically on just on this issue, as well as his the prior finding determination of intellectual disability.
Court will take judicial notice of the finding of intellectual disability. It's on file with the court. The court's taking judicial notice of that report, which I believe was dated from the evaluation of July 20th, 2017.
Yes, sir. As well as Mr. Boylan being on the sex offender registration list.
Right, court will find that Mr. Boylan is a registrant with the state under chapter 62.
As well as the nature of the present allegations in the criminal matter.
Yeah, court finds and states for the record, Mr. Boylan's charges in this matter being that of possession of child pornography, in addition to failure to comply as a sex offender registration.
And then the state would ask the court to make a finding that Mr. Boylan represents a substantial risk of physical impairment or injury to himself or others.
Court's also going to take judicial notice of the finding of incompetency by the Well Path Recovery Solutions Montgomery County Mental Health Treatment Facility that was completed December, or by letter, December 19th, 2023, by Dr. James Pittman. Court does, based on the evidence, find that Mr. Boylan does represent a substantial risk of physical impairment or injury to himself or others.
And finally, Your Honor, state asks the court to find that he is unable to provide for and is not providing for his most basic personal and physical needs.
Court does make a finding that based on the evidence that Mr. Boylan is unable to provide for his most basic needs and treatment is necessary. Further from state.
Your Honor,
The court does also find that he is not currently charged with an offense listed in Texas Code of Criminal Procedure 17.0328.
thank you, Your Honor. And finally, the state would ask the court to order that Mr. Boylan be committed to a facility designated by the Texas Health and Human Services Commission until such time as residential placement is available.
Right, courts based on the evidence and also the court noting the waiver of the defendant with counsel, Mr. Johnson Manning orders that Mr. Boylan be committed to a facility designated by the Texas Health and Human Services Commission until such time as residential placement is available. I said residential placement is for an indefinite period until we get a finding of competency or some other issue that brings Mr. Boylan back to the jurisdiction of the board.
And nothing further from the state, Your Honor.
Mr. Manning, anything further from Mr. Boylan?
Judge, that comports with the stipulations and the record that we've made. I would ask the court to proceed with the finding and place him in the mental health hospital caseload in order for him to be continuing receiving treatment.
Right, court does grant your request, Mr. Manning. The court has signed the order of civil commitment. The court will provide this to the Health and Human Services Commission so that Mr. Boylan can get the treatment that he needs.
Judge, that concludes anything we have on this issue.
All right, Mr. Boylan, I hope I'm confident we'll find a good place for you to go soon. Just bear with them as they continue to do that. And I hope you remain in good health and good spirits. Okay.
Well, I know, Mr. Young, I've been working
You've been working.
on my charges. I know one place that will take me, because I talked to the owner of the place, and he said, because he's using, because when I go outside to have my cigarette, they let me have one cigarette a day. And when the caregiver's there at the group home, y'all could come and take me to whatever side the hospital, but you must stay in the window side.
Okay. Well, we're going to try to find the best placement for you. And like Mr. Manning said, he's right. Okay. I don't necessarily get to say which hospital you go to. I have to look and listen to the Health and Human Services. They're going to try to find the best place for you that's available right now. And that's what we're going to try to get you. So we can't necessarily just go say, hey, I want Mr. Boylan to go to this hospital or that hospital, but we have to work with what's available. So whenever you do get transported over there, I want you to go in there and, make sure that you're nice to everyone, make sure that everyone knows that you're there and that you're willing to help and comply with rules and, let them see your real personality. And I think if they see your real personality, you're going to get along just great with everyone. Okay.
Because there's this one inmate, every time we go in the gym, he punches me in the eye for no reason.
Okay. I'll have Ms. Abraham talk to the jail staff over there. We'll see if we can put a stop to that, okay? All right,
But I fixed it, I talked to, the manager here. I'm in the six cell.
okay, well, let Ms. Abraham talk to the
Talk
jail.
to the jail staff, okay?
We'll see if we can make things better for you, okay?
Judge, may I be excused at this time?
Yes, you're free to go, Mr. Manning. Good to see you, Mr. Boylan.
All right, and he'll be back. Fabio will be back to take care of Mr. Sanders.
Okay, I won't be on the lookout.
Thank you, sir.